Well, Florida gun laws just flipped entirely, confusing pretty much everybody in the state. And today I'm going to tell you exactly what's going on. As Florida has had a long-standing ban on open carry, but now they've unbanned it. But the interesting part is that it's not only confusing some gun owners, but then there's also sheriffs that are refusing to acknowledge this and actually keep the ban in place in their own districts. I'm going to tell you what their argument is for keeping the ban in place or continuing to enforce the ban, and I'm going to give you my argument against it. Now, of course, I'd love to hear your opinion. Do you think these sheriffs are in the right for upholding this ban still, or do you think they're in the wrong? Let me know down below. Let's go and jump right in. So September 10th is when the 1st District Court of Appeals actually said that the open carry law that's been in place since 1987, by the way, is unconstitutional. Then the Attorney General, James Uthmeier, weighed in and said, look, this is the new law of the land. Open carry is now lawful and no agencies should be enforcing this. The problem is it's an appellate court in one district, so other districts have yet to weigh in, and of course the Supreme Court has not weighed in on this decision yet. So this is where it leads to some of these kind of gray areas, and now people really don't know what's going on. So if you don't know the laws in Florida, first of all, they have permitless carry. This has been in place since, I think, July 1st of 2023. Now, there is still a permit system in place that you can get as well. Now, before this appellate court weighed in and the Attorney General subsequently, essentially Florida had pretty much a ban on open carry unless you were actively hunting or fishing for law enforcement, of course. And if by accident, like let's say your shirt rode up and temporarily, somebody was able to actually see your firearm, right? You couldn't pull your shirt up and reveal it to try to intimidate somebody or anything like that, but that's pretty normal across the states. Regardless, for all intents and purposes, open carry was pretty much banned. So here's what Floridians can now technically do is obviously conceal carry, right? With or without a permit, as long as you meet the eligibility requirements in the state. And then they can openly carry, but again, some sheriffs have said, well, we're going to continue to enforce this. Now, Florida also has this kind of interesting thing about your car. So you can carry a firearm in your vehicle as long as there's basically a two-part process to get to the firearm. Meaning, you can have it in a glove compartment, whether it's locked or unlocked. You could have it in a zipped up bag. You could have it in a holster with a snap. I don't know if they would include something like a toaster, right? That kind of snaps in place, so you physically have to pull it out of the holster before you can use it. But that's the whole thing, is if you're carrying in a vehicle, they want you to be able to go through one process, which is either open in a console, open in a bag, whatever, and then be able to pull the firearm out. But what you can't do is have the firearm just like under your seat, right? And so just super quick access. You can't carry it on your person, again, if you meet those requirements. But you cannot carry in so-called sensitive places. So these are pretty much going to be gun-free zones. So schools, courthouses, polling places, police stations, private property owners. They can have a no firearms sign and bar you from their property if you have a firearm as well. Now, I was looking up to see, because essentially what they're using is Bruin here to set forward, has there always been a historical ban on open carry? And of course, we know here in the United States, there has not been. So that's how they lifted the ban. But I wanted to see, has there been a historical ban on so-called sensitive places? And I actually found one in Texas in 1870, where they barred people from carrying guns in schools, churches, and election precincts. And so courthouses and all of that have always been like off limits. So they can say essentially that, historically in the United States, for at least a period of time, there have been some places that we've deemed you cannot carry your firearm. But of course, this list has grown over time. That's one of the biggest issues that people have. So while that part of it can still be upheld, again, how long does this list get before we just finally say, okay, I think it's easier for you to tell me where I can carry as opposed to where I can't? Because essentially they can almost deem anywhere a sensitive place if they wanted to. So that's one of the confusing parts, but I think what's even more confusing is what the sheriffs are doing here. And this is one of the scariest things because the law can't keep up with enforcement. So you're throwing around these mixed signals. Maybe I can do it in this district, not this district, so on and so forth. And this creates, what can be a pretty legal mess for a lot of gun owners, right? Imagine getting pulled over by a police officer and they don't know the ban was struck down. Or worse, you get into a self-defense situation and they say, oh, you were openly carrying, and now you have to defend yourself. And so that's why the sponsor for this video is perfect. They're attorneys on retainer. I signed up with them months ago. After 10 years with the USCCA, I decided to leave them and sign up with a real law firm. They're not an insurance company. They're a law firm. They give you people from day one, and they have 3 criteria to cover you. It's very simple. Fine print and all that I'm not a fan of it, right? And so 3 criteria. Use your firearm in a justifiable self-defense. You acted in good faith, or you believe you did. You are charged or think you could reasonably charge with a misdemeanor or a felony, and you're a member at the time of the self-defense incident. These cases can run into the tens of thousands of dollars. When you look at some of them, Kayla Giles, I think her case has been going on since 2017, and most people just simply have to plea out because they can't afford to retain a lawyer, which means they don't retain their rights either. They cover a ton of different things, right? If you're in a gun-free zone and you had to use your firearm. There's one case they covered recently where the guy, went from Florida to New York. His gun is technically illegal in New York because of round capacity, because New York decided, 10 rounds is safe for the public. Anything over that is not. Attorneys on retainer was able to get those charges dropped. 24/7 response team, training, mental health sources, expungements, red flag laws. They have a lot. And the best thing is they're not bound to all of these restrictions when they cover you. They're not looking for some of these gray areas that could potentially leave you without anybody on your side. They can stand beside you when others legally cannot. And so anyways, I became an armed affiliate with them. If you want to sign up for you and your family, the pricing is spot on as well. If you add on a spouse or anybody in your family, like I said, the cost is amazing. So essentially you get $25 on the one-time sign-up fee if you use the link in the description and my discount code down below. Really fantastic. I'm glad I made the switch. They're covered in all 50 states, but if you live in one of these states especially, it just seems like this stuff is ever changing. If you ever have to use your firearm in self-defense, you should never have to lose your rights as well. There you go. Big thanks to those guys for sponsoring today's video. So to further convolute this situation, you have the First District Court of Appeals that says this is no longer the law of the land, right? We're repealing this ban. Attorney General agrees and says no agency should be enforcing this. But other sheriffs in other districts, which by the way aren't held to the same standards as the first one, meaning that first district has no jurisdiction over the others. And these other sheriffs are saying, hey, it's still in the statutes, so we're going to continue to enforce it unless the Supreme Court steps in or it's changed in the legislature. And these sheriffs don't necessarily answer to the AG, even though he's the top legal person in the state. They are elected constitutional officers. And they're saying, oh, well, if this decision is later upheld or overturned, or they disagree with it in another appellate court, then they're saying they risk, lawsuits from selective enforcement, internal audits, or even claims of dereliction. But here's the thing, because they are under the Florida and United States Constitution, that means they should be enforcing and protecting the Constitution, not just what's being seen as outdated laws or statutes. When you have a competent jurisdiction that says that this statute violates the Second Amendment, the top legal officer in the state agrees, and you continue to enforce it, what they're actually doing is opening themselves up to civil lawsuits down the road. If they decide to stop somebody that's open carrying, charge them with a crime for openly carrying that firearm, there definitely could be lawsuits. So you almost can kind of see what they're saying at first, but then it just quickly falls apart when you realize that, hey, you have a duty to uphold the Constitution, not necessarily a duty to uphold statutes from 1987 that have been deemed to violate the Second Amendment. So it's almost like, yeah, you want clarity in the state. I get that, right? Supreme Court should step in and clear this up for everybody, put it into the legislature, remove this outdated way of thinking. For sure, I agree with that. But until then, you've already had it from the AG that you should not be enforcing this. So I think by them choosing to go against the AG and enforcing this, they're going to open themselves up to more lawsuits. So these sheriffs that are thinking they're just playing it safe by enforcing this outdated statute, in my opinion, are actually just choosing to infringe upon a fundamental right. These things are always changing, and so gun owners are kind of stuck in the middle to almost play their own lawyers in a way and say, well, what legally can I do or can't I do now? This opens up a much bigger issue that happens in a lot of states, even ones that are more pro-gun. We're seeing some positive change in Florida. We're seeing an opening for freedom, but it's definitely not coming without some hiccups along the way. I'd love to hear your opinion though, whatever it might be. Let me know down below. If you like what I do, consider subscribing. See you in the next one, and as always, hold 'em down.